Good morning, everyone. After several false starts, I am going to just mow through this material, and I don't care if there's flubs along the way, because if I was in a traditional brick and mortar class, faux pas and mistakes happen along the way. So let's get through it. What I wanted to put up today was a short summary review of chapter or of amendment number 6 and amendment number 8. The Sixth Amendment deals with civil liberties and civil rights related to criminal law. And the Eighth Amendment deals with the question of bail and cruel and unusual punishments. Not that they're entirely related, but they are distinct from the Seventh Amendment. I'll just tell you what the Seventh Amendment is right now. I'm probably not going to test you on it. I doubt it very much. You should know it, though. The Seventh Amendment basically provides that in civil cases, you retain the right to have a jury trial, both parties, plaintiff and defendant, because civil usually requires that there be two parties, not the government versus the defendant. It might be two civil entities, two companies, two individuals. In civil trial, the right to have a jury trial shall be retained, meaning we still have that right, provided that the amount in controversy is $20 or more. And this is the important part, and it was recognized at common law, meaning at the time the Constitution was created and the Bill of Rights were written, there was a recognition that you'd have a right to a jury trial in that circumstance. So many people think you always have a right to a jury trial whenever you go to court. That's not true. You have it in every criminal case because of the Sixth Amendment, and you have it in many civil cases because of the Seventh Amendment. But what does it have to be? Worth more than $20, and it had to be recognized at the time the Constitution was created to be appropriate for a jury trial. So what don't we have jury trials over? Things like workers' compensation benefits. If you sue for workers' compensation benefits, you go to an administrative law judge. You don't have a jury there. It wasn't recognized at common law, so therefore the government can set up a different scheme of justice, not requiring a jury. Divorce and family law in Massachusetts is entirely in front of a judge. There's no juries in Massachusetts over family law matters because the Constitution doesn't mandate it. That doesn't mean the state couldn't provide for jury trials if it wanted to. It's just a question whether it's required under the Seventh Amendment. So that's the Seventh Amendment of the way. You have a right to jury trials in many civil circumstances if it was the practice at the time the Constitution was written and the claim or controversy is worth more than $20. But let's get to the Sixth Amendment. Sixth Amendment only applies to criminal actions, meaning the government. At the inception, it was about the federal government, and later we're going to learn through incorporation of the 14th Amendment made states have to follow this principle. So now whether it's a state court action or a federal court action in the criminal realm, these are the following rights a defendant has. The first, that they have a right to a speedy and public trial. Now, speedy doesn't mean the same day or the day after you're charged, because that would be fundamentally unfair to both sides. So there have been cases that have come down, and there are statutes that help clarify and define what it means to have a speedy trial. But we don't want people detained against their liberty or have a charge hanging over your head, because you're not always detained pending the outcome of a trial. But there should be fairly rapid access to a trial. We don't want people to linger on this on either side. The defendant can always waive the right to a speedy trial, because this is the defendant's right to have a speedy trial. The defendant can waive it because they say, my attorney and myself, or just myself, I need more time to look for witnesses or gather information, so I'm going to waive the right to a speedy trial. There is more of an urgency if the defendant is incarcerated. There's statutes usually 120 days or 6 months. There's certain time frames both on the federal and state level to comply with this in order to get the defendant before a jury trial. And so a speedy trial. Now, what does that mean? Again, case laws determine that, and statutes have helped determine what a speedy trial actually is. But it should be done without undue delay. And there's an old saying, justice delayed is justice denied. Those of you that have ever been charged with a crime, or a family member, or myself, I'm a criminal defense attorney. I know when my clients are ready to go to trial, and sometimes we can't docket it for several more months, they feel very anxious about it, and they want to resolve it, and they want to bring it to resolution through a jury trial process. You can imagine if they could either hold you or just simply let the case linger for a long time, it can be very detrimental, not only emotionally, but potentially economically and for a number of other factors in your life. So it has to be a speedy trial in public. We don't have secret trials. The only time we used to have secret trials is for the protection of the defendant, and that's in the juvenile setting. But all adults, 18 or over, if you're charged with a crime, the trial has to be public. A lot of people think, well, I want a private trial because, this is a sexual assault case, so the victim wants it private. It doesn't work that way. All trials are public. Sometimes certain information can be impounded to protect the interests of the parties involved, but for the most part, we want transparency, because if trials are public, we know no one is getting railroaded, whether it's the prosecution getting railroaded because the defendant's very popular or wealthy. And the same with, we don't want the defendant to be treated unfairly either. We want, because of the public having access to watch criminal proceedings, that level of transparency arguably keeps the judiciary honest and have integrity in how trials are conducted and evidence is introduced and things like that. So speedy and public trial is the first element. The next one, which gets a little confusing, it's an impartial jury. It's not a jury of your peers, although there was some historical evidence that when people were writing about this amendment, they suggested that meant jurors of your peer. We were a much more homogenous society at the time the amendment was written. But I don't know, when I think of a jury of peers, I think people like me ethnically, maybe age, maybe being a male, maybe with similar religious backgrounds, similar philosophy. I don't know. You see how to actually require that they be a jury of your peers might be a very difficult litmus test and very almost impossible to create. So nowhere in the federal Constitution has it been interpreted that you're really entitled to a jury of your peers, and what that means different things to different people. But you are entitled to an impartial jury, meaning they don't have a stake in the outcome. They already haven't prejudged it. You know, if it's a lawsuit against you for say you're charged with OUI, and one of the potential jurors had lost a child to a drunk driver. That's not an impartial juror, probably, so they should probably be excused and be allowed to sit on a different kind of trial because of impartiality. Or you're a friend of the cop, or you're a friend of the defendant, or you're a friend of the victim of a case if there's a victim involved. Those kinds of things make the jury prejudicial, and so therefore we don't want that. We want fair trials, so they must be impartial. And then the next one, it must be impartial jury of the state and district wherein the crime has been committed. Think about it. Why did they put that in there? You have to remember what the colonists were going through, that were starting to get, a little bit towards revolt. They were revolting over the fact that the British government was so dissatisfied with the jury, especially in Boston, because they were finding many of the colonists that were doing things that were against the British crown. They were finding them not guilty. So the British Crown got very frustrated. So they were taking the defendants charged with a crime somewhere in Massachusetts. They were sending them up to Halifax or up to Nova Scotia to be tried. And that made it fundamentally unfair because they weren't really tried within the community where the events allegedly took place. Now, this is the defendant's right. So the defendant can waive it. And sometimes the court will allow the defendant to be tried in an area outside the venue of where the event happened because of fairness, because sometimes say it's a very sensational case, a defendant has done something allegedly very heinous and it's very sensational, it's in the press and everyone's talking about it. To be tried within that community is going to be hard to find very impartial jurors, so the venue can be waived. But if it's not waived, the defendant has a right to be tried right in the community where the appropriate court is located for the nature of the offense that happened in that community. The next is to be informed of the nature and the cause of the accusation. They have to tell you the who, what, when, and where of what happened, what you're charged with, what statute have I allegedly violated, what rule or regulation have I allegedly violated, when, who was there. You've got to give me all that information. Sometimes you call it a bill of particulars, those of you really interested in this stuff. And you'd be surprised sometimes someone's charged and they won't have enough information like that, and it's subject to a dismissal if they can't provide enough information to a defendant as to the nature of why they're accused of a crime. I had a case like that in a juvenile court. And by the way, all of these, other than the public aspect of a trial, all the Bill of Rights apply to juvenile cases as well. But I had a defendant, it was a big group, supposedly event where a group of maybe 10 or 12 kids supposedly broke into a big garage and stole ATVs and other equipment. And they listed what one kid did, what another kid did. And at the end, they listed about 4 other kids. And these kids also did it. But they didn't say what they did specifically or what the things they took. So I was successful. I had one of those kids, and I was successful in getting a motion dismissed because it violated the Sixth Amendment. They didn't tell them how, what, where they actually committed the crime. It didn't withstand probable cause. But think about it. Imagine being arrested today and thrown in jail and said, "What am I here for?" And I say, "We'll tell you later, maybe." You're entitled to know at arraignment. That's what the formal process of arraignment is, to let you know the nature of what you're charged so you can prepare. Maybe you weren't there, or maybe you were involved in some of the aspects, but one of the elements, yeah, I burned down the building. It's my building, and I had permission from the fire department to burn it down because it was in a big open field and it was an old barn, and I wanted to have the fire department practice their skills on it. So I had consent to do it, and I had a permit. So how could it possibly be arson? It's got to be the property of another. So sometimes by being told what you're charged with, you might have an appropriate defense, excuse, or right to have been involved in what you have potentially done. Or it may just not be you. It's not me. It's impossible to be there. I have proof I was in another location at the time. Maybe it was someone that looked like me, or the like. So you need to be told of what you've done. This is the big one. I think, well, they're all big, and this amendment's huge. To write in the obligation that the government has to actually produce the witness against you. You have a right to be confronted by the witnesses against you. And this is where the principle of hearsay comes in. Think about it. Some cops come forward, they arrest you, and they said, you robbed the Cumberland Farms down at the end of your street on such and such a date and time. And the first thing you probably say is, who said that? None of your business. Or, we can't tell you. We're going to keep it anonymous because we want to protect them. You can't. You have a right to be confronted, meaning you have a right to have them come to court and say, yeah, I saw it. This was Jim Corman. I know him. I've met him before. He had glasses on. He's got the sort of red hair, bald spot in the back of his head. He drives such and such a car. I saw him pull in at such and such an hour. And that way, through that kind of confrontation with the witness that actually saw, heard, smelled, experienced the moment, you could cross-examine. Isn't it true that you hate Jim Corman because you were involved in a business with him at one time and it went sour and you felt like you were cheated? Or is it true that the parking lot at Cumberland Farms is very dark? You said it was at 2 a.m. and we had a power outage that night, and it wasn't true there wasn't any artificial lighting at all, so it was very difficult to see who was going in and out. My Cousin Vinny stuff, movie I refused to watch for the longest period of time because I don't like usually law movies. I think they're usually awful. That one wasn't bad because it showed by being confronted with the witnesses that actually saw, heard, experienced the events. Sometimes it's not because they're lying. Sometimes it's because their ability to perceive is subject to questioning and doubt. And if you didn't get confronted with them, all they brought in was a piece of paper. Can't do that. That's hearsay. And same for the defense. Sometimes I've had this happen in one of my very first jury trials. Thank goodness it got postponed. I'm all amped up for trial. I show up an hour early, tell my client to show up an hour early. We're outside the court, talk to him. And I said, hey, luckily I summoned in all the witnesses that were going to testify on my client's behalf. I said, geez, I hope your friends show up. It's getting closer to the bill, which hour. I know I summoned them in, and I always remember him saying, oh, I got good news. I said, he said, they're not coming. I said, how's that good news? These are our witnesses. These are the ones who goes, yeah, but I had them write out statements about what they saw and heard and experienced, but I had it notarized. Oh, it's still hearsay. The prosecutor can't cross-examine a piece of paper, and notarization doesn't mean anything other than whoever signed it says they are who they are. They supposedly did it freely and voluntarily. That doesn't mean they didn't have bias or confusion or promises made to them, and they aren't subject to cross-examination. So we don't allow, in most circumstances, hearsay to come into evidence because of the Sixth Amendment. You're right. You have a right to be confronted against your witness. Now, that seems real easy to many of you. But then what if you have, and not to get too dark on this issue, but what if somebody allegedly injured a child? My mom's new boyfriend came over the house, and when she went out to go shopping for a while, he got mad at me and he beat me up. And say it's a little kid, 8 years old. And the DA records the 8-year-old telling the story about how mom's new boyfriend beat him up when mom was away at the store and how he's scared to death of that guy. Should we be able to just use that video in court? Well, some people will say yes, but the law is going to say otherwise because the Sixth Amendment allows defendants to be confronted with the witnesses. So you'd have to put that 8-year-old on the stand. And that's where the rub is. That's where the difficulty is with this amendment. Some people say it makes a victim twice because somebody like me, although I like to think I'm a gentleman and I'm civil and I would always ask questions in the most appropriate way, when I ask that 8-year-old about questions about the event, it might be difficult for that child to answer those questions because I might ask questions about, isn't it true you don't like your mom's new boyfriend? Isn't it true that you didn't have any cuts or bruises? Isn't it true you made up the story just to get this guy thrown out of your family's situation? And that can really traumatize a child. And I admit it, it's true, but democracy isn't always, and freedom isn't always clean and easy to apply. And the right to confrontation is a very important fundamental right, because if you've ever been charged with a crime, or you know someone that's been charged with a crime, you'll bet dollars to donuts you're going to want to be able, especially if you didn't do it, always if you didn't do it, you want to be able to confront the witnesses that say you did it. So you might be able to establish your innocence, even though that's not your obligation, but they failed to establish your guilt because either they had motive to lie, or they just simply didn't observe the situation correctly. So confrontation of witnesses is very big. The next one a lot of people don't talk about is to be confronted with, to have compulsory process for obtaining witnesses of your own. So defendants have the right to actually use the government. The government has to help out. That's usually the sheriff's department or some constable. They actually will bring in witnesses on your behalf if you request them to testify on your behalf. The government has to provide that service for you. Whether you're rich or indigent, that service is available. And that's a very good tool, because sometimes you're going to need these people to come and tell you. You want compulsory process. You want them under the color of law to be called in to testify on your behalf. And if they don't show up, we usually continue trial and actually put on a warrant for these defendants if they don't show up under just a mere summons, which is just a document you get in the mail. Some of these people don't show up, then they get a warrant because they violated a court order. The next one, this is the one I'm going to put up a video that I didn't do, somebody else did. And this is the big one, the right to have assistance of counsel. You always have a right to hire an attorney, whether it's criminal or civil, but you always have the right to have one appointed to you. Well, it seems that the Sixth Amendment says in a criminal case, you do have a right to an attorney. However, you have to remember all of the amendments were originally applicable to what? Only the federal government. Most cases are state courts, local community courts. These are state actions. So for the longest period of time, right up into the 1950s and early 1960s, states did not have to provide attorneys for poor people charged with a crime. That got overturned by a famous case called Gideon versus Wainwright. And there's a famous book written by it called Gideon's Trumpet. It's written by a guy right here from Massachusetts, passed away maybe 5 years ago. And Gideon was just a poor guy, got convicted down in Florida, and got 3 to 5 on some burglary. He kept asking for an attorney. The district court judge politely says, well, the state of Florida doesn't have to give an attorney. And he says, but the Sixth Amendment says I shall be given the right to the assistance of counsel. And the judge at the time was correct and says, I'm sorry, sir, but that only applies to federal cases. This is a state case. That all changed with Gideon. Gideon, on handwritten paper, appealed to the Supreme Court saying we should have appointment of counsel in any criminal case where our liberty is at stake. And the Supreme Court said just that. Justice Hugo Black, one of the more interesting justice in terms of a complex history, once a member of the Ku Klux Klan, but as a Supreme Court member, advocated significantly for the poor and disenfranchised and often minorities when it comes to the rights to have a counsel appointed. He was a huge advocate of it, and he won out in the end. And so that means in any proceeding, state, federal, or otherwise, in a criminal matter, where your liberty can be taken. If your liberty can't be taken, the court does not have to appoint counsel. Occasionally, those of you that like to watch court, and I'm in court a lot, you'll see the judge say, you're charged with driving after suspension of a motor vehicle license. It's a criminal matter, but it's your first offense. I am going to make a finding that there's no possibility of jail time. So you can either hire your own attorney or you can represent yourself. And sometimes the defendant will say, well, I'd like the court to appoint me a public defender or an attorney from the government to represent my interests. And the judge will say no, because there's no risk of jail time. So that's one of the elements a lot of people don't know about. You have to risk potentially going to jail in order to be appointed counsel. And the next thing you have to be is what? You have to be indigent. You have to be poor. If you're wealthy, go pay for your own attorney. And one of the questions I sometimes ask is, can you represent yourself? You can always represent yourself. I wouldn't do it, and I'm a licensed attorney, I've been practicing for 27 years. I would never represent myself in anything that has legal ramifications, because you get emotional and you focus on something that you think is important, but there's a whole plethora of other issues, and it's very difficult to present the case on your own behalf. I really think it's wise to have counsel, whether you're wealthy, poor, or otherwise. I don't care how gifted you are. And I met some people that have represented themselves. If you've gone through the paralegal program at the Mount, because that's how they got the bug, they got charged with some crime, they were upset with the attorney they had, they fired him, they did it on their own, they won the case, and now they're really intrigued about becoming a lawyer or paralegal and working in the legal field because they think they got a knack for it. And many of them do. Very dangerous. Don't represent yourself. So that's it for the Sixth Amendment. Again, it was only applicable to the federal government for the longest period of time until this doctrine of incorporation, that the 14th Amendment said no state can deprive its citizen of due process of law and equal protection of law, meaning that the other amendments, over time, different cases did it, but they incorporated the core essence of all the amendments to be applicable to state action. That's the Sixth Amendment. I'm going to skip over the Seventh, went over it earlier in the video. Now the Eighth Amendment, very short amendment, says excessive bail shall not be required. This is very controversial. What's bail? The posting of money to ensure your return. It's a surety. It's a motivation for you to return. So how do we determine it? The Supreme Court and the other court cases have told us over time that bail is only appropriate in circumstances where the defendant doesn't seem likely or has an impetus or a motive not to appear to court. So the more serious the charge, the more likely you'll flee justice. The less likely if you have limited ties to the community. I'm in Florida for one event, and I committed allegedly a fairly serious crime down in Florida. I have no family down there. I have maybe a long criminal record up here in Massachusetts, but no ties to Florida. There, bail might be appropriate, and the amount of bail is relative to the likelihood of failing to appear. And so they look at things like your community ties. What's the likelihood of you staying in the community? And they look at your record. Not only just because you have a long record doesn't mean bail will be high. It might mean it'll be very low, because you might have a long record, and guess what you've done every single time you've been charged with a crime? You show up to court. That's the only test of bail, likelihood to return to court. The legislature, and it's been held as constitutional, some crimes are so heinous and so fearful of the defendant failing to appear for justice that they have the right to give no bail. Certain murder cases, you don't have a right to bail. The judge can say you're held without bail. Certain other crimes, too, can be no bail. Now, careful. A lot of people say, well, the defendant's going to go out and commit another crime. It's not a question for bail, that you might be a danger to the community. There's other statutes that protect the Commonwealth or the government or the society from dangerous people. It's a special hearing called the dangerousness hearing. So that's not a bail question. No. Bail is just about what? Test question. Likelihood to return to court. And we go through this analysis about seriousness of crime, ties to community, your past record of appearing to court or not. And that's why a lot of people get troubled, and a lot of them are police officers. Some of you want to be police officers. They often will arrest somebody objectively of not a very serious case. And what do they see later on? They see that same person they arrested the day before out in the public enjoying themselves like anybody else, and cops get upset. And so do other people in society get upset. The problem is they haven't been convicted of a crime yet, and that's exactly what you should be. If you haven't been convicted of a crime, your liberty shouldn't be taken away until due process of law, until you've actually been convicted of a crime. But it troubles a lot of people. I remember my father, one time there was a guy that was the chief of police out in Holyoke, and he was in the news. I grew up in Springfield, so we used to get the Holyoke news a lot. And the chief of police was up there ranting and raving about the judges in Springfield or Hampden County. He said, oh, they're awful, they're worse. I myself arrested 3 of those women that are standing outside my window right now, those prostitutes. I arrested them yesterday for prostitution, and they're on the street doing it right now. What kind of society do we have? What kind of law do we have? This is outrageous. The point is usually for prostitution, first offense, or even a few offense, you're probably not going to do jail time anyways, and these people probably didn't have much of a risk to leave the community. And so people think that when people are out on bail, there's an outrage, especially if you're the victim of a crime. And I know somebody broke into my house, and I know they stole some of my stuff, and they caught him, maybe red-handed. The police came, they caught him red-handed because of an alarm system or something. They caught him red-handed, and maybe because I'm so into it, I go to court the next day when they're arraigned. And what if the judge releases them on either no bail, personal recognizance, or releases them on $500 cash bail, and the guy comes up with it, and I see that defendant in my neighborhood? Won't I be outraged? Sure, but we don't make policy based upon our personal sense of justice. We make it upon a broader conception of liberty needs to be preserved until someone is validly convicted. Now, of course, if somebody commits a second crime while the first crime's out, we do have mechanisms to revoke bail because someone is becoming a danger to the community by just being a repeat offender. Even though they've been convicted of nothing, I've had this happen. I represented a woman recently where she had 2 or 3 cases pending. She was released on personal recognizance. She allegedly committed a 4th, and the judge said because there's probable cause she's committed another case while out on personal recognizance, he revoked her bail, and the statute in Massachusetts is for 90 days. So for 90 days, she was held without the right to bail because of violating the terms of release, namely not committing any new crimes allegedly. I don't like that rule. I think it's unconstitutional, but hey, I'm not the law. The Constitution and the courts tell us what the law means. So the 8th Amendment, bail is the first element. The second one, no excessive fines imposed or cruel and unusual punishments. This is where we can disagree, or maybe we agree. What does it mean to be cruel and unusual? Is chopping off the hand of a repeat thief, yeah, thief. What's wrong with me today? Chopping off their hand. Somebody says, yeah, let's do it, especially if it's their third or fourth offense. I think that would be cruel and unusual punishment. I think cruel and unusual punishment is when you send somebody away for life because they've committed 3 felonies in their lifetime. When you look at the specific felonies, the third one might be forcibly taking a box of pizza from a pizza guy in the restaurant and leaving. That's a type of robbery. Robbery sounds very serious, but when you look at the facts in and of itself, it's not huge. But because that person has 2 felonies in their lifetime, we're going to send them away for the rest of their life. I find those kind of minimum mandatories very, very cruel and unusual. You might find them different. Where do we find the answer? The court, the power of judicial review, Marbury versus Madison. And I'm an anti-death penalty guy. I'll confess to you right now. I just don't like my government killing people, and I think the death penalty is disparately given. I think poor people, minorities, are more likely to get the death penalty than white, rich people for the same exact offense. And I'm a white, rich person. I'm just recognizing something I think is wrong. And therefore, because I think the rule is equitably applied, I don't like it. But am I wrong? I'm not wrong to not like it. But am I wrong about it saying it's cruel and unusual? Yes, I am. It's not cruel and unusual punishment because we know when the amendment was created, the death penalty was, pun intended, alive and well. So death penalty in and of itself is not unconstitutional. But the methods by which we do it, whom it might apply to, do we give it to people with significant diminished capacity that suffer from low IQs? Do we give it to very young defendants? And what crimes apply to the death penalty? You were caught jaywalking, it's time to execute you. Obviously, it goes too far. So those are where the parameters are. And it's the courts that tell us what is cruel and unusual punishment. Every so often we'll hear of a judge sentencing somebody to something like they're to walk up and down the street with a big, sandwich board saying, I'm an idiot. I was texting while driving and I got in an accident. They walk up and down in front of some public forum to humiliate them. To me, that's unusual punishment. But how sometimes the court gets around it, they say, well, okay, I'll give you 30 days in jail, or if you agree, you can get a year's probation and you have to do the following things. Now it's not a punishment imposed by the court, it's by agreement with the defendant. That's how I think they get around that. But I don't know how they do some of these unusual things where defendants are ordered to do acts of public humiliation. So that's the Eighth Amendment. And so now we've covered, I think, the core criminal defense. I shouldn't say defense, but the criminal procedural protections we have. Because remember, it's not everyone thinks it's about protecting the criminals. If you're an innocent person and you've been charged with a crime, you'll be thankful that we have a constitution that gives us these prophylactic procedural rules. So that way, if you get convicted, there's a very good chance, not pure, it's not a perfect system, but a great many people that do get convicted were in fact guilty. Are there innocent people that do get convicted? Sure, but less so because of these rules. It's challenging. A lot of people think it's too challenging, meaning the criminal defendant has a lot of rights and the victim doesn't have any. But a free society, we want to make sure that people who are guilty are actually proven guilty through a process like this. The Ninth Amendment we'll talk about a little later. It does provide some privacy rights. It's not been used nearly as much. 10th Amendment, state rights. But then we're going to spend a lot of time on the 14th Amendment because that's a game changer. That's where the federal government became expansively powerful because it had the right to ensure not only in public spheres, but in private spheres as well, that discrimination has to end in most circumstances. Employment, services such as restaurants and hotels, all of those kinds of things, both privately and publicly, discriminatory acts have to stop when it comes to race, color, creed, national origin, religion, sex. And the federal government has the power to enforce it through statutes like the Civil Rights Act of 1964. Really a huge game changer. And it was really born out of the Civil War. But that's it for criminal. Put up a little assignment-related criminal, and I hope I don't forget, but I'm going to put up that little video that's excellent about Gideon versus Wainwright, about how the federal government finally was not the only one applicable to the Bill of Rights, but also the states in many circumstances.